Well, welcome everyone. It's 3:30. We'll open up the Lost Pines Groundwater Conservation District Board meeting for this Wednesday, December 18th, 2024. It is 3:31 p.m. Um, we have a full quorum now. Director Phillips just joined us. Hello. So welcome to everyone. Also would like to welcome Judge Malinak. Hello, Judge, Lee County Judge. And also welcome to our essay winners. And we'll get that to that in our regular agenda. So with that, if you could all please stand for the Pledge of Allegiance and the Texas Pledge. Pledge allegiance to the flag of the United States of America. Honor the Texas flag. Pledge allegiance to the under God, one indivisible. Thank you. So with that, we'll move on to agenda item number 2, public comments. If you have not yet signed up for public comments, please do so. I have got, see a question. I've got public comments from Chris Pepper representing Rambo Materials and also Eric Allman representing environmental stewardship. I would imagine we're going to be discussing in our regular agenda the Rambo hearing, and you will have an opportunity to have closing statements, all parties. So would you like to reserve your statements for that period of time? Okay. So then skipping to the other public comments, we have received written comments from SAWDEF. And those have been distributed on the dais. And so with that, we will have Judge Frank Malinak for public comments. And this would be on a non-agenda item.
Right.
Welcome.
Yes, thank you. I just would like everybody to be aware, and I think probably most of y'all are, of a proposed compost facility coming to the Lincoln area of Lee County. We got notice of this first part of November, and the more we studied this, the worse it got. And the TCEQ permit application, so to speak, the public comments ends on January 2nd. So this is a very short window here. But what the permit application says, they're going to be bringing in waste from things like restaurants and businesses and apartment complexes and it didn't specifically say on there vet clinics and hospitals, but here's what it included. It included meats, fish, dairy products, animal carcasses. So that I'm assuming that some of that's going to come from maybe vet clinics. And in front of all those things, you could put rotten because it's spoiled meat, it's leftover food coming from restaurants and so forth from the city of Austin, and they're going to put it into a tract of land out here outside of Lincoln. They're going to put it out there on the ground, and they're going to mix it with vegetation, grass clippings, what have you, and then it's going to sit there on top of the ground, and it's going to rot. It's going to putrefy by bacterial action to create composting material. This is going to stink to high heaven. I've been out there. I've looked at the property. When we get a rainstorm out there, what's going to happen then? We're going to have bacteria and viruses, possibly dangerous pathogens, washing down the Yawar Creek. And I was told by the owner himself that there won't be but one truckload a week. Well, that's 52 truckloads a year. How long before that's going to damage our creeks all the way down to Lake Somerville And if it damages our surface water, eventually it's going to damage our groundwater. So I wanted y'all to be aware of this. What our situation is, we have a county ordinance against solid waste disposal here in the county. And it looks like maybe that's going to be challenged, but we would like this group's support for us on what we're doing, because we just do not want to allow this kind of pollution here in the county that could affect the quality of our surface water and our groundwater. And anybody got any questions for me or anything?
They're not required to at least cover it up or to, I mean, that's gonna be budget different.
Look, we've seen photographs where this company has done this in Austin, and they have got mounds taller than this building. So it's not covered up, and the buzzards are sitting all across the top and all around the area houses and everything else because of what's in that content. So yeah, it's not a pretty sight. Yes.
How large a tract of land is it?
It's 50-something acres, and maybe y'all remember maybe something from the newspaper. I don't remember now, but the tract of land that is on the proposed PCQ website is I think maybe 30 acres, something like that, which when you get right down to it, that's a small tract of land to be doing something like this on. And they only have to set this back 50 feet. 50 feet. Imagine living across the road from that. I mean, holy smoke. So,
What's the nearest waterway?
Yaywell Creek. And it's, as you stand on top of a little valley there, the valley stretches out below. You can see the proposed site over here and the creek. There's a creek that runs right over here that runs into the West Yaywell Creek.
And TCQ has given blessing.
TCEQ, this is kind of a strange animal because it's like they were giving us notice that this was coming. Not notice that we're going to consider this, but notice this was coming. And apparently TCEQ has set these rules that if you're going to compost and you follow these rules, then you're good to go. But we're going to challenge that. So again, because we have a county ordinance specifically preventing that. That's the last thing that we want. And some of the photographs that are online on their Facebook show the sites that they are proudly dumping this stuff. And there is trash and paper and plastic bags. It looks like a landfill instead of, fruits and vegetables out there on the ground that are going to be composted like we would, at our own house, our own property.
What's the target date for startup?
Well, we don't know. The issue is that the end of that period is January 2nd. So we don't know when they put the switch on and say, when they're going to start doing that.
It would be a good idea for somebody to do some water quality of Yaywell Creek before they start composting.
We have got a group that is doing water quality testing in conjunction with Texas A&M with the middle Yaywell Creek, because right now the middle Yaywell Creek has got a higher than allowed E. coli content in it. And we're trying to figure out where that's coming from. Is that coming from somebody's leaking septic tank, or is that coming from wild hogs, or what have you? So that's in the process right now. Right now, the citizens in the county and Texas A&M have joined together to put together a water program, water quality program for the middle Yaywell Creek. Well, our position is if we're fighting that because TCEQ sets those rules on what those levels should be, we have agreed. We're trying to do something about that and clean that up, but yet we've got TCEQ now proposing that this stuff essentially be allowed to go into the West Yaywell Creek, which runs into the middle Yaywell Creek eventually, and then on down into Lake Somerville. So that is,
Yes, the Yewell Creek Watershed Protection Plan, which goes to EPA, there's like a 30-day comment period. I think that ends this month.
Yeah.
So it should start working anytime.
but that's how we know that the E. coli levels are higher in the middle Yewell Creek.
Yeah.
Now, the West Yewell Creek hasn't been tested, but you can just imagine what's gonna happen if this slop runs off down into the West Yewell Creek, what that's gonna cause. And, look, we fish and swim, and Little Boston's not swimming in Yewell Creek, but we use that for recreation and we want it to be as clean as what we can. And we do not want this facility allowed in Lee County.
What was the name of the company again?
Break it down.
Break it down.
No, I was just saying that we could take this offline with our general manager, Mr. Totten, to work with you and see
Right.
how we can assist.
As y'all may know, the county 2 weeks ago at our last regular commissioners court meeting, we passed a resolution against it. And so we're prepared to do what we can to protect the waterways of Lee County and the rights of our citizens too.
We appreciate you bringing it to our attention,
Okay,
and we'll have Jim reach out to you.
okay. All right, thank you. Did I see Annie walk in?
No, he's not gonna be here.
We could investigate to see how it would impact the potential.
Yeah, management plan does.
Yeah, so we could look into that.
Would have an education out from watershed protection.
As y'all can imagine, I got tons of stuff going on right now, so I'm gonna step out after that, but thank y'all for everybody.
Thank you.
Thank
you.
sir. Okay, next up, I've got, Miss Lynn Clancy for, public comments on agenda item 4E. Now would be the proper time for you to make your statements.
Good afternoon, board and, general manager Scott Union. My name is Lynn Clancy. I represent the Lower Colorado River Authority. I'm here primarily to answer questions on the application to amend two well locations for the Griffith Lake Ranch wells. Our expert is joining by Zoom in case there are any questions, and I just wanted you to be aware of that. They're relatively straightforward, simple moves to accommodate some requests from U.S. Fish and Wildlife Service due to Houston toad endangered species habitat and to accommodate a landowner's request that we set a well further back from the property than it was originally permitted.
When we get to that agenda item, if there's any questions, we'll have you come back up.
Sure.
Thank you. With that, anybody else with public comments? Anybody online? Might have public comments. All right, seeing no chat and no one online and no one here in the room, then we will move on to our consent agenda. Agenda item 3. Consent agenda items are routine and will be enacted by one motion. There will be no separate discussion or action on these items unless requested by a board director. Anyone would like to pull anything out of the consent agenda? All right, looks like we're good. I'll entertain a motion.
I'll make a motion to approve the consent agenda.
Second.
Okay, motion made by Director Cole, seconded by not yours. I'm so used to calling Kay by her first name Kay that by Director Rogers. All those in favor, please say aye. Any opposed? Hearing none, motion passes. All right, regular agenda item 4A, announcements. I guess the one announcement would be just to wish everyone a Merry Christmas and a Happy New Year. That would be one. Anyone else with any other announcements? Okay, then what I'm going to do is I'm going to change up the agenda a little bit so we can do the presentation of the awards first, so that they could move on, and if they don't, if they wish. So we will, first do the agenda item 4C next, which is the presentation of the awards for the high school essay scholarship winners. Claire, would you like to say some introduction remarks here? So the essays were in your packets.
Yes, so hopefully you got a chance to read them. Myself and the education committee read through them. We had a predetermined guidelines and criteria that we actually graded these essays on. We had 4 submissions and 3 outstanding essays. The first place was Emma Roth. She is from Bastrop County. She is homeschooled. The second is Caitlin Shelton. She is in Lee County at Giddings High School. And then Braden Mute, and he is also Giddings High School. They were phenomenal. It was honestly hard for us to rank the 3 because they all were so good. So having that guidelines in place that was predetermined, this gets this many points, that really helped us make the final decision.
So congratulations to our winners.
Okay, all right, so I'm gonna call your name and come on up here and we're gonna snap a picture with you and Elvis. So Emma, if you could come up here, that'd be great. Congratulations. Oh,
Congrats.
thank you. Awesome. Okay, and then if you wouldn't mind just standing right here, we'll do a group one. Okay, Caitlin, do you want to come up? And Brayden. Wonderful. Okay, let's do one of all 3 of you and Elvin. Great job.
Thanks.
Thanks, guys.
Congratulations.
Good job.
All right, next agenda item, regular agenda item 4B. The final hearing in accordance with Rule 15.1.E.2E on the October 14, 2024 order issued by Judge Stephen Abels on the application by Rambo Materials LLC, application number 2022-4177, recommending denial of environmental stewardship's request for party status, motion contesting administrative completeness, and motion for reconsideration. The final procedure in Rule 15.2.H will be followed for argument on the order. With that, Mr. Ellis, I guess we'll set the procedures for the process moving forward here.
Okay, as we've always done in the past, I serve as special counsel to the board to advise the board on these contested matters. The general counsel in this instance is representing the general manager's position and actually serves as a party within that hearing process. So the general manager's counsel, Bobby Salahi, will be making oral argument. We're going to hear from the applicant first. The applicant may reserve part of their time for rebuttal after that. Then we'll hear from the protestant, environmental stewardship, and finally we'll hear from the general manager, potentially rebuttal from the applicant. This is not a position, this is not an opportunity to put on any additional evidence. Remember, you're not allowed to consider any evidence record. This is an opportunity for them to make their oral argument. Following that, we will most likely go into executive session so we can have a discussion on what your options are in a closed session. And then the board will have to come out and make a final decision in an open meeting. Are there any questions about the process at this point?
time limit. So there'll be a 10-minute time limit, per party. And, folks could reserve time for rebuttal.
The applicant can.
The applicant can, okay? So first up will be the applicant. So Rambo Materials, so I guess, Mr. Pepper.
Good afternoon, ladies and gentlemen. My name is Chris Pepper. I don't appear before y'all very often, so I wish you Merry Christmas. I'm just as nervous this time as I was last time. The first time I've ever been in this room was on October the 2nd. I sat right there. And I wanted to tell you about October the 2nd. We had a preliminary hearing according to y'all's rules on October the 2nd for the permit application that's before you. I've been an environmental lawyer for 23 years. I'm from Blanco, Texas. I've known the permit applicant, Adam Schexnayder with Rambo Materials, for about 10 years. The consultant, Brandon, put together the application. He lives down in Bernie, Texas. My co-counsel is Paul Sarahan and the associate attorney who works for me. Our permit application is for a relatively small amount of water, about 100 acre-feet on 200 acres of land that we own. We need to use this water to wash our agriculture. Our operation is going to be a sand and gravel quarry. It's heavily regulated by the EPA, mostly by the TCEQ from an environmental standpoint, also by you guys, believe it or not, by Sid Miller's bunch, the Texas Department of Agriculture, believe it or not, the Army Corps of Engineers, believe it or not, something called MSHA, the Mining Safety Health Administration. There's going to be a lot of eyes on this plant. Y'all may not know this, but they've been in business for 12 months. The quickest way for them to go out of business is if they cause a problem on that river. The location of this plant is on the Walt Burton Bend, pretty famous area in y'all's neck of the woods. It's also heavily developed, and I'm not telling anything y'all don't know. There's a lot of folks doing a lot of development over there. The quickest way for the people who are concerned or worried or who are affected by this application after they get into business is to file a nuisance action or to file a trespass action. And I can assure you, having practiced environmental law for 23 years, that our client will face a tough time if they do bad things there. With that, I'm going to reserve the rest of it. I need to tell you one more thing about it. I don't know Judge Abels. I've never met him. He was online that day, but he's a lot older than me. He's from Kerrville and he's smart. And I have a feeling he's seen a lot of administrative law because I read his resume. What he did was unique in this case. In my opinion, as a Texas Aggie, he started off and was going to grant these folks standing. They don't live that far away, or they own land relatively close. But once he asked them questions, and once I asked them questions, and even after opposing counsel tried to rehabilitate the witnesses, he says no. He says, I didn't hear anything credible that they would be affected persons. They have water in an alluvial aquifer that is relatively shallow, about 50 feet, 65 feet below the surface, real close to the Colorado River. About 5,000 feet from my client's property. That's about a mile. And it's about 5 nautical miles upstream from my client's property. About 2.5 nautical miles upstream from a really large hotel complex called the Lost Pines High. With that, thank y'all for being here today. We would like to be good neighbors to the folks in Walls County that y'all regulate in Bastrop County and in Lee County. And I save the rest of my time for rebuttal. Merry Christmas.
Okay. Yes, next up is Mr. Eric Allman, representing Environmental Stewardship.
I'm Eric Holman here on behalf of Environmental Stewardship. The hearing is temporary as they make two general types of errors. First, he entertained the opposition to Environmental Stewardship's party status despite a written stipulation prior to the preliminary hearing by Randall saying, no, we do not contest Environmental Stewardship's party status in this matter. And second, he erred in finding that Environmental Stewardship was not an affected person. Now, there's some things to keep in mind as you sit here today and consider your role in this process. One is you do not owe deference to the hearing examiner. This decision is yours under the statute, it's yours to make. Second, this is a matter of just whether environmental stewardship is a party. This is not the time to litigate the merits of the application. In fact, the Texas Supreme Court has said that when you have a situation like this where the merits overlap with standing, it's similar to a summary judgment in district court where all facts asserted by the person seeking standing are accepted as true and all the allegations are interpreted liberally in favor of the protestant. Now, in this case, the lack of notice violated environmental stewardship due process rights. Courts are to enforce agreements because they help make things more efficient. Prior to this hearing that was held, Rainbow Materials had filed a written brief in which it said in writing explicitly, Rainbow Materials does not contest the party status of environmental stewardship or its members. And we attended that hearing with that understanding. For that reason, we didn't spend the several $100s to have an expert present on that day because we had not been notified that there would be a protest. And yet the applicant stood up to protest our party status. It was improper for the judge to consider that. That was a violation of our due process to entertain a protest that had not been given notice of. Secondly, environmental stewardship far exceeded the standard for standing. When participation in a hearing is consistent with the organization's purpose, we only need to have one member who would have standing otherwise. In this case, we presented member Ron Hershaft, who owns a well in the area. I've been before you a number of times, but I'm still getting a hang of it. So we also presented the affidavit of Mr. Jordan. There we go. We also presented the affidavit of Mr. George Wright. Once the hearing was concluded, and we had the chance to file a request for reconsideration. And the motion before you was a ruling on the request for reconsideration as well. Now, Mr. Rice testified that formations in the area are.
I'm going to object to this.
And he's
Mr.
gonna
Ellis.
object to that as well.
This is new evidence. The record closed at the end of the preliminary hearing. The affidavit was dated on October 4th and the hearing was on the 2nd. So the record closed at the end of that preliminary hearing.
The order states that it is a ruling on the request for reconsideration. Our request for reconsideration and the affidavit attached to it is part of the record that was developed before the hearing examiner. It's part of the record before this board.
I guess it's on me, huh?
I would have to agree with counsel that this affidavit was not part of the original set of evidence. I believe in reconsideration, this information can be used, but I believe at this point it's not appropriate.
And that is what we are here for, is to ask you to consider the judges. You have the judge's order before you. That judge's order included a ruling on the request for reconsideration, which was part of the process that occurred at the hearing and before the hearing examiner. So since it's part of the record that was before the hearing examiner, considered by the hearing examiner and ruled on by the hearing examiner, it is properly part of the record for you to consider here today. And again, being that the reason for that request for reconsideration was lack of notice for the hearing when their hearing was held. And from that part of the record, it's being reviewed on appeal by any court to look at your opinion. So the folks who have interest in what it says.
I think what the presiding officer is trying to say is that for the purposes of considering the motion for reconsideration, you can look at the record as presented as part of that motion. In terms of the decision on party status, that record is closed. So that can't be considered in terms of that. But again, you can consider it only for the purpose of whether or not the overall decision should be reconsidered. Does that make sense?
But the affidavit was part of the motion for reconsideration.
Right.
So it's part of the record there that was dealt with for hearings.
It's part of the record. Part of the record for the motion for reconsideration. It was not made a part of the record on the initial decision.
Yes, and that order is what's before this tribunal on the request for reconsideration as well as the hearing.
Well, I think if you cover what's in the memo in terms of why the decision should be reconsidered, you'll be within the bounds. If you go beyond that, then I think you may have gone outside the bounds.
Well, certainly.
If I may, in Judge Abel's order, he describes what he based his ruling on, and I quote, having considered the evidence presented, the district's rules, relevant case law, the arguments of the applicant and protests, that affidavit was not considered, so it's not part of the record. And it's District Rule 15.2H is pretty clear. Additional evidence may not be submitted during the final hearing, which is what is happening here today.
No, that was part of the arguments when he referenced having considered the arguments that was labeled supplemental arguments and request for reconsideration. It was part of the arguments that had been considered. And certainly the judge had an email, which I can put for you, that ruled on that referred to that as argument.
I mean, my view is that the judge did not add this when he made his initial ruling. We have not seen this. We have not read it. We have no idea what's in that. And it would imagine, my understanding is that we need to stick to what was discussed on that October 2nd hearing.
You should have seen it. It should have been part of the record that was provided to you. This was part of the record for the hearings.
We have not seen that affidavit that you were referring to.
So am I being denied the opportunity to discuss that affidavit in any way?
I think you can discuss the affidavit purely in terms of why the decision should be reconsidered.
Can I ask a question? So was there an order on the motion for reconsideration?
Yeah.
And the judge had a hearing on that?
He didn't have a separate hearing, but he ruled against the motion to reconsider.
And you're saying that that's part of the record that we're reviewing?
Yes, that was before the judge when he made the rule.
And they're saying that's not part of the evidence that he looked at? But you're saying it's part, how are we distinguishing evidence and record?
Well, the record was what was presented during the hearing. So that's the official record of evidence during the hearing. There was a motion for reconsideration that included that additional affidavit, which Judge Abels had an opportunity to review, and then he denied the motion for reconsideration.
In writing?
As part of his order, yes. So that's
And
what
what
I'm
I hear-
saying. You could, if you want to argue it should be reconsidered, that affidavit was something that Judge Abels did have in front of him at the time that he considered the motion to reconsider it, which he denied. But in terms of granting party status, okay, let me put it this way. There's two ways the decision, I see the decision can go today. One decision could be that the board believes that the hearing examiner should have reconsidered the initial decision. In which case, we're going to remand this back to the hearing examiner to conduct a further hearing. If you don't decide that, then the next thing is whether or not you're going to uphold the initial decision was made to deny party status. And you can, at that point, you can rule on that question. So there's, you all tell me if you think I'm off base here, but I think there's two parts to it. Should that initial decision be reconsidered? If not, should the board uphold the decision of the hearing examiner to deny party status? To the extent that he's arguing it should be reconsidered, I think you can look at whatever evidence was presented to the judge on the motion for reconsideration, but that's it.
So the path is either we agree with the judgment or we reroute it back to the hearings examiner.
If you decide it should be reconsidered, you can send it back to the hearing examiner.
And those are the only two things we can do.
Right, because in my opinion, the hearing record itself does not include the evidence that would grant them party status. So I don't think you grant them party status today. I think you can remand it back by granting the motion for reconsideration.
Greg, are you saying that the judge has seen something that we have not seen as part of the record?
I think that's correct. I don't think that we sent the motion for reconsideration and the affidavit to the board. I'm not sure if they've,
Know.
you know, have they seen that motion for reconsideration evidence?
I don't
Yeah.
think so.
I don't think so.
As far as the affidavit included, because it was after the record closed, and we're here on order number 2, which denied party status, as well as the motion for administrative completeness. That's something we're here to consider today. The Judge Abels was clear in what he considered to base his decision on, which was the rules, case law, arguments for the applicant and protests, and it wasn't the affidavit, or he didn't talk about the motion for reconsideration in his order.
But the order does mention the request for reconsideration because it specifically mentions this. This was an issue in the drafting of the order. The order initially did not include a ruling on the request for reconsideration. We said, hold it. The judge just issued a ruling on that by email. That's part of what he has decided. And it was agreed, okay, yes, we will include that in this order because this order is deciding the request for reconsideration. The judge could not have possibly referenced the request for reconsideration and said he was ruling on it if he hadn't considered it part of the record that was before him. Say somehow he made a ruling on the request for reconsideration, but the request for reconsideration is not part of the record for him. Makes no sense. And that order is what is before you for you to consider. You should consider what the judge considered in making the order that you're here to review.
Yeah, the judge's order specifically says, in conclusion, environmental stewardship's motion contesting administrative completeness, its supplemental argument in motion for reconsideration, and its request for party status in the pending matter are denied.
So he specifically considers that and the argument. And that's what we're here to ask you to do is consider his order, that he considers his affidavit.
And again, I think that you can address the affidavit to the extent that you're using that to justify reconsideration.
Yeah, and that's what I'm voting for, justify this board's need to grant party status, that the request for reconsideration should have been granted by the judge instead of denied by the judge.
Again, I think you can argue that they should grant the motion for reconsideration, in which case we're going to remand it back to him for further action.
Yeah, and so, and I'm not trying to go outside your bounds, I'm trying to understand. And so in that context is where I'm quoting from Mr. Rice's affidavit. It was part of that request for reconsideration. Part of the material before the judge when he issued the order that's now under your.
All right, I'm gonna be real as late as I can here. At the end of the hearing, the judge essentially ruled that we did not have enough evidence in the record to support granting party status to environmental stewardship. You filed a motion for reconsideration. You attached an affidavit to that would have been that evidence had it been presented during the hearing. The judge denied that. It doesn't say anywhere in the order why he denied that. I presume he denied that because that evidence should have been presented during the hearing, not as an afterthought. So, I'm not trying to tie your hands here. I think that you can make your argument that the motion, the initial decision should be reconsidered. And I want you to have full ability to make that argument. But I think that where the first part you're going to have a hard time overcoming is, where was that evidence during the original hearing?
And again, part of this, again, this was a violation of the process because we were told hearing, I have a copy of that page of the brief filed by Randall saying we do not contest environmental stewardship party status.
Object. And if he has a copy, he can read it.
I don't have 15 copies, I'm sorry. If you go, you want to take of it?
Thank you. Eric, are you gonna read it?
Yeah, I'll read it. Yeah, if you'd like to.
Since I objected, but I wanted the board to understand the reason for the objection, Eric made a representation a while ago that said Rambo was not contesting, but Eric left out 4 really important words that he's fixing to read.
Because. Says Rambo Materials does not contest the party status of environmental stewardship or its members. That is the whole heading, as you can see before you. It said, as long as they come here, answer questions, and it lists certain questions they were to be able to answer. We had them attend the hearing. They were there and they answered these questions when they were asked. So we met all conditions set forth of the not contesting party status for environmental stewardship. For the judge to then entertain a protest, and Rambo had said, Rambo Materials does not contest the party status environmental stewardship or its members. You say, well, you're now citing from your expert who wasn't there. There's a reason the expert wasn't there. The expert wasn't there because our standing was not supposed to be contested. We weren't going to spend several $100s on an expert to be available for a hearing where our standing was not contested.
So it's your argument today that unless the applicant or somebody else protests your participation as a party, that you're not required to put on the evidence showing that you qualify for party status.
It's our argument that when we've been put on notice that party status is not a contested issue at preliminary hearing, then we can prepare for the hearing in reasonable expectation that party status is not going to be contested. And as the court says, that stipulations are being enforced. I mean, this is helping make the process more efficient. We should have stipulations like this where it makes the process of testing less expensive. If you know the party status is not going to be contested.
There was no stipulations made. A stipulation is when 2 lawyers get together and they tell a judge or a general counsel that they've agreed on something. These were contested briefs and they were written for a purpose. And he still hasn't written the 3 words with the comma that are very meaningful to the words that were written in this brief.
This is their written brief before the hearing. And so, well, certainly. So am I allowed to discuss what Mr. Rice said in his affidavit, or am I not allowed to mention that? I'm trying to figure that out.
I think that you can quote that to the extent that it supports your motion for reconsideration, but I really think you need to concentrate on why the decision should be reconsidered. And that's the argument I think you're making now.
Yes, we believe the decision should be reconsidered, and we've been doing so. The proper standard is that for standing, which says that the evidence presented by the person seeking party status is to be accepted as true. And in reconsideration, they have importantly considered that during the hearing, there were allegations made, such as from counsel, saying that these are far apart, they're not connected. No evidence of any type was put on by Rambo. They presented no expert. They just had a counsel saying they're so far apart, they're not going to be connected. There was no geologist to say that.
I'm going to object again, you guys. When Eric uses the word evidence, there was evidence presented by his own witnesses in the case when they looked at a slideshow that we emailed Eric and his legal assistant along with the judge, and they said, you know, we're way up here. We're up here next to the Colorado River. We're further north. That's what Mr. Khan had said. He's in the courtroom today. I don't see Mr. Hirsch. Evidence, words matter, and I look forward to my 5 minutes of rebuttal.
Yes, I look forward to waiting for his 5 minutes of rebuttal. Yes, having those distances is one thing. Having an expert who can say those distances matter is another. Again, you know, in reconsideration, we think, you know, Dr. Rice said in his affidavit, due to this interconnected nature of the formation, something in the amount, depth, and location which Rambo has proposed will potentially cause a lowering of water levels in Mr. Hirsch's well. You want to say these impacts could have consequences for his ability to use water from his well. But there was no expert there that day of the hearing to address whether these are interconnected or not and what impacts would be there. That was the first time anybody heard from an expert. That's the only expert anybody heard from to say these are interconnected. On that day of the hearing, there was questioning of our witnesses who were lay witnesses, members there who are not experts, saying, well, how far apart are they? And they admitted how far apart they were. And are you just concerned if they're that distance? They say, no, we're not as concerned if it's that distance as opposed to closer distance. But it's no small thing to throw somebody out and say they don't have standing. It is denying them an opportunity to engage in discovery and actually have a hearing. These issues we're discussing right now are supposed to be decided at a hearing on merits. That's why this decision was improper, because it tried to decide the issue of whether these wells were impacted, when that's what you should have decided during the hearing on merits. And we'll note there's a principle involved here that the courts have also said standing in administrative hearings is broader than that in judicial proceedings, because in administrative hearings, you're trying to ensure that you hear from a diversity of viewpoints. Environmental stewardship showed up to hearing to try and present you with that diversity of information, present you with the geological analysis of this application. Because we were denied standing, you don't have that information before you. We would ask that you remand this for another kind of preliminary hearing and for a hearing on the merits so that we can develop that information and get that before you so you can more meaningfully consider their application and the geological impacts that it will have.
One last question. Eric,
Yeah.
who has, in a preliminary hearing on party status, who has the burden of proof?
The burden on the person seeking party status is to raise an issue of fact on if a decision goes to both the merits and the standing, the burden on the person seeking party status is to raise an issue of fact, which means you just have a conflict in the evidence. As I would understand it, an issue is not conclusively resolved in one. If it's not overlapping, you have to actually prove it. For instance, did we have a member in an issue where the facts don't overlap with merits? We proved by did we have a member? As to whether the well would be impacted, that is an issue that not only goes to standing, but also goes to the merits. And so all we had to do, our only burden at that preliminary hearing is to show there's an issue of fact here. There's a reasonable dispute as to whether this well would be impacted. We don't have to prove it by any means at that preliminary hearing to demonstrate that we can stand.
So what I hear you saying, and I think I agree with this, you don't have to prove your case that there's going to be an impact. But you do have to sufficiently raise the issue that there's a justiciable issue here to be decided, right?
Yes, and we would contest that even if you look only at what was at that preliminary hearing, that we did so. Because we presented two witnesses, each with wells. Mr. Hershep had a well. He testified that it was only about 500 feet from this. An expert later looked it up, it was further away, and that expert did an evaluation based on the expert's opinion. And so that land that Mr. Hershep owns is right there adjacent to it. He owns water within the Cooper Aquifer, which is also the aquifer from which these wells draw. That was undisputed at the preliminary hearing. We said, we're concerned about the impact this is going to have on area groundwater. They presented no expert. There was no witness there that in any way contested our contention that these were connected and they would have an impact. We think, given that we presented concerns and the evidence being that proximity, being that nearness, that closeness of the well, we think raised the fact issue as whether or not an impact would occur. Given that there was no opposing evidence presented at the preliminary hearing, even if you looked at just that and didn't look at the request for reconsideration, you feel that we raised the fact issue as whether or not we could be impacted, and that our request for party status should have been granted rather than simply rolling it out and depriving this board of the information that would be developed before hearing itself.
We're ready here for the gentleman here now.
Yeah. Thank you for your help.
Good afternoon. My name is Bobby Solihi, representing General Manager Jim Todd in this matter. The GM has no exceptions to the hearing examiner Abel's order number 2. The GM recommends adoption of the order without any changes. I'm available to answer any questions the board may have if there are any. But I'd like to read an excerpt from District Rules 15.1.E.2.C for preliminary hearing. The sole purpose at the preliminary hearing shall be: 1, whether the person requesting a contested case hearing has standing to protest the application, and 2, whether the person requesting the contested case hearing has raised a justiciable issue related to the application. As such, notice was adequately issued and went out to all interested parties. The general manager believes there is no issue of any due process violation for this permit application. Thank you.
Any questions?
What's the standard used to decide if someone has standing?
They have to show that they are going to be impacted by this application. And that standard is raising that justiciable issue that they're going to be impacted in a way uncommon to general members of the public. That's the standard that I have. Yeah, you have to have that personal justiciable interest.
Pepper?
Thank you, Bobby, and thank you, Eric. The burden is on environmental stewardship to get standing. They're seeking something called associational standing. That means one of their individual members needs to have standing in his or her own right. That means they need to be affected differently than you or me or you, because they're really close, or they have a registered well in the Hooper Formation. It's real important for me to establish credibility with this board. And it's real important that I use clear speak, just like I do with my teenagers. Please be home at midnight. Mr. Allman and environmental stewardship confuse issues. They speak in a language of confusion. Whether or not the application was administratively complete, there was a letter, July of this year, very clearly says it's administratively complete and provides a bunch of reasons why. Mr. Allman chose to argue with the judge about that. The reason that this application is unique is because it's for a very small amount of water, consistent with your production limits in section 9 of your rules, which were adopted, I think, in June or July of 2023, which helped establish that a small amount of water, groundwater taken, a half of acre foot per surface acre, there's a presumption that that's not going to cause a problem. Facts matter, and facts win cases. Our client, my client, has an alluvial well on its 200 acres. Our client is not going to dig a Hooper well that's going to impact its alluvial well. The opponents in this case are located a long way away. They were put under Vordar by me. They had the opportunity to be rehabilitated by their attorney, and the judge asked questions to him, and they denied party status. And with that, I close.
All right, so with that, we will enter into executive session. Item 5A, executive session of the board pursuant to Texas Code Section 551.071, or any closed session permitted by law. Item 4B, related to the application by Rambo Materials LLC. Application number 2022-4177. And we will go into executive session at 4:25 p.m. The board is reconvened at 4:47. There was no action taken, no votes were taken. So we will continue with our regular agenda item 4B discussion. Anyone with any further questions?
It seems to me that they're asking us to let them put in evidence after evidence was closed.
Can you use the mic?
Your mic on.
It may not even be on, but Jim will check for you.
It seems to me that they're asking us to send it back to the examiner so they can hear additional evidence that was not presented in the first hearing. And when the first hearing is closed, that should, in my opinion. So,
I'd like to make a motion.
Okay.
I'd like to make a motion that we remand the matter back to the hearings examiner for reconsideration.
Second.
Okay, we have a motion by Director Rogers and a second by Director Smith to remand the matter back to the hearing examiner. Correct? I guess we'll go and do a roll call. Director Arsufi,
Agreed.
Smith,
Aye.
Phillips, Director Textor,
Yes.
Director Phillips, Director Semay,
No.
Director Cook. No. Director
Yes.
Cole, yes, and Director Rogers.
Yes.
Yes, and I will, it's a difficult decision, but I guess I will vote yes with everyone else, so the motion passes 8-2. So, with that, we will move on to the regular agenda, item 4D. Discussion, consideration, and possible action on request of Aqua Water Supply Corporation for a permit amendment to add a new well under District Rule 7.2.c. Mr. Totten, any update?
Yes, so this was originally posted to be taken up last month, but we listed it as a replacement rather than an amendment. So that brings it back to us this month. The Aqua is looking to add a new well to an their existing S field, which is located along Highway 304 south of Bastrop near Shiloh Road. This particular well is on Lower Red Rock Road, just a little bit south of Shiloh. So this is a no increase amendment. We've processed these before with other permit holders. They're basically seeking to add the capacity to produce more water without actually changing the amount they're authorized to produce on an annual basis. So it is, as I said in the past, it's been a fairly common practice when either due to failures in well design or loss of capacity in wells, the permit can apply to add new wells to an existing permit without increasing the annual production. I'd be happy to answer any questions you have.
Any questions, Mr. Totten?
Yes, I have a question. One of our public comments from Andy Ware, noted some concerns about nearby wells. Do you have any concerns about impacts? I mean, I have nothing against it. I would just like to know where he's coming from.
So he's referring to nearby exempt wells.
Yeah, there was a map that was presented to us, that was provided to us. We got it just yesterday. I think.
Yes, ma'am.
maybe
So
I had a chance to look at it.
So twofold. One, all of the modeling that we've done, at least during my time here, has always assumed that S field would eventually produce all of its permitted amount, regardless of the number of wells that were needed. That S field has always been ramped up to meet the eventually its full permit. So from the perspective of, the possible hydrologic impacts have been modeled, for the last 10 years at least. With regard to possible impacts in that area, that is a less prolific area of the Simsboro. The Simsboro sort of pinches off as you move south from the Colorado River. So it is possible that there'll be more response in the hydrologic conditions because of production from the S field. Counterbalancing that, the district does have its mitigation program, which would cover well owners that are impacted in that area. So is it a perfect solution? Not necessarily, but we do have the ability to offset impacts that, to those well owners that might be caused by adding this new, and again, it's not new production, it's just a new well on the existing permit.
That's what I wanted to hear.
Yes, ma'am.
Haven't we done some mitigation payments for wells in that area, like Reed Sharp?
We've had, I think, 3 or 4 in that area, yes, ma'am.
I mean, so do you think this will cause more or?
It's possible. Again, it's not the most prolific part of the aquifer, so we're not really increasing the annual production, but will be adding, it's another point source of flowing water from the aquifer in that area. I would say compared to what we're seeing in North Lee County and what we're likely to see in South Bastrop County in the coming years, the impacts are gonna be relatively muted compared to those. But there probably will be a few more wells that need to be mitigated, yes, ma'am.
So does having the mitigation program kind of make these decisions easier for you?
Well, I don't make the decision, ma'am, but.
Well, no, I mean, the recommendations, okay?
So there was a trade-off that, we made when the user board chose to implement mitigation, is that on some level, that does lower the emphasis that would be put on the consideration of impacts to exempt wells. Because we, as a district, have committed to making those people whole. So that was part of the mitigation process. But whether it makes it easier for me or not, it depends on the applicant, it depends on the day.
One more question. I don't know if this might be for Aqua, but does Aqua provide service in the immediate vicinity of that well? Or is the water going someplace else?
There you go. I was gonna say, I believe they do, but Daisy from the back said, yes, they definitely do.
Thank you.
And just for the record, all of this amount, this entire permitted amount has already been in our models for, years prior. So all this has been modeled and taken into account.
Yes, sir. Okay. Obviously not this particular well, but again,
Yeah,
this well falls within the kind of existing confines of the S field.
yes, field.
So it doesn't dramatically have any, changes to the modeling.
Any other questions? Either for Mr. Totten or for Aqua? I'll entertain a motion.
I move that we approve their request.
Okay, motion by Director Smith to approve the permit amendment request by Aqua. Do I hear a second?
Second.
Second by Director Cook. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, the motion passes. Item 4E, discussion, consideration, and possible action on the request of Lower Colorado River Authority for permit amendment to relocate a well under District Rule 7.2.c. Mr. Cotton, any comments?
Mr. President, members of the board, I would say this is actually an application to move 4 wells that are of the total, 8 wells are, that were permitted on the Griffith Lake Ranch. Been 4 years now, I think. Yeah, it was right around the end of COVID era that we had the contested case. As LCRA's attorney mentioned, 2 of these wells are being moved at the request of Fish and Wildlife to move the wells away from areas that are known to be toad habitat. The other 2 wells are being moved in response to an agreement made with landowners that were in the area to try and minimize the impact of those wells on adjacent landowners. From the district's perspective, I don't see an issue with moving any of them. It doesn't significantly change the modeling or projected impacts associated with the project. I know that Andy Weir's written comments raised questions about amending a permit during litigation. I would defer to the man in the suit to answer that question, but from a strictly hydrologic and procedural standpoint, I don't see an issue with making these modifications to the permit.
Okay, well, in question, I guess, to our legal counsel, I mean, this permit, we are getting monies from LCRA on this permit, so it looked like this is a granted permit for 8,000 acre feet, and we are getting monies from them. Is there any concern that this is in litigation potentially, or?
President Hernandez, currently, there's no petition that's been filed to the Supreme Court on that litigation you speak of. Therefore, the third court's decision disposing of the case right now is the final decision on these permits. Now, if they did appeal and the Supreme Court granted cert, we believe that any amendment would be abated until the court disposes of that case once and for all. So my recommendation to the board is that you proceed with the understanding that the amendment will not take effect until the case has proceeded through the Supreme Court if they do grant cert. But as of today, we believe that the third court's decision is the final decision as of now.
Okay, so as of today, it's, okay, it's final. Question?
Yeah,
Yes, sir.
Jim, you said 4 wells, but when I look at my map, I just see yellow dots for 3 wells, so I see 8, 7, and 4.
I may have,
That's correct.
I misspoke, so.
And only 2 require amendments.
Okay.
Okay, so it's only regarding 2. Would you like to say something? Speak? Yeah, come on up.
Yes, thank you, Lynn Clancy again for LCRA. We have 2 that will move more than 100 feet, therefore they're requiring amendment. Well, number 7 is moving less than 100 feet, and so it didn't require an amendment. To the point of whether these amendments need to be abated while any litigation proceeds, if it does, I would argue that that would be inappropriate. The permits were granted, you've issued an order. As you've recognized, President Hernandez, LCRA has been paying its permit fees for all 8 permits. These changes in location are to wells that would be used even if LCRA only gets 8,000 acre feet. Those wells are the wells that would be the first to be developed as part of the project and are needed to address some of our federal comments. I would encourage you not to have that kind of abatement because I don't think it would be appropriate. Thank you.
Yeah, this does not change the permitted amount of 8,000 acre feet. Right.
This is just Fish and Wildlife, Houston Toad,
Yeah, and
which
the,
probably trumps us.
and the neighbors,
Yeah.
and they've gotten some agreement with, I guess, some
They're
neighbors
farther away
to
from the
move farther,
backyard.
farther away from the property. Excuse me? They haven't
Oh,
drilled.
they've never been.
Yeah, my understanding is these haven't not been drilled yet at all.
Correct.
Yeah.
Maybe we approve the amendment.
Second.
Okay, motion to approve, the, amendment, for well relocation, made by Director Smith and seconded by Director Arsufi. All those in favor, please say aye. Aye. Any opposed? All right, with that, motion passes. Item 4F, discussion, consideration, and possible action on the groundwater management area 12 interlocal agreement cost sharing proposal. Jim, an update on, what happened? We created this agenda before the GMA 12 meeting, so we didn't know what was gonna happen at the GMA 12. So we had this in here kind of as a placeholder in case the GMA 12 made some progress. They have not, we're still waiting on a cost estimate by the consultants.
This agreement runs the risk of becoming the Flying Dutchman of agenda items at the GMA. But the one bit of headway, you're absolutely correct. We are still waiting for cost estimates for the explanatory report. Brazos Valley, the Brazos Valley Board met, reviewed the interlocal that we had prepared and sent out for review. And they came back with the comment that they felt that the cost should be shared more or less more equally between the 3 major districts, Brazos Valley, Post Oak, and Lost Pines. As you may recall, we had originally proposed, I believe it was 33% for Post Oak and Brazos Valley, 30% for Lost Pines. It looks like we may be moving to a 30-30-30 split with the remaining 2 districts picking up 5% each, because 30 is in line with what you as a board had initially approved. We'll take this matter back up in February at the GMA meeting. At this point in time, we have another board meeting between now and then. If I feel like I need to come back and get some guidance, some more flexibility, we can take that up in January. But for right now, it's really kind of just in limbo until we get the cost estimates back. So
Yeah, but the cost estimate is so that Fayette County GCD and East Texas GCD can kind of determine, is 5% too much or too, or how much is 5%? So that they know if they have the budget for it.
They don't have much budget.
Right.
5% of what was the
5%
question that
of
came
what
up
was the
several
question.
times
So,
during the discussion.
Until we get an answer on that in February, we probably can't move on this until that.
But-
Questions?
But at this point in time, I'm thinking 30% for the three big districts and 5% for the two remaining is the most likely way this will end up playing out. So that's kind of where we'll go. But if I need more direction or if I hear that something else is going on between now and February, we'll take it up at the next board meeting.
Do you feel like you have the flexibility to go somewhere between 30 and 33%?
No, ma'am. Not at this point.
No, we've only given them direction to go up to 30.
Like I say, we'll have another board meeting, at least one, maybe two before the next GMA meeting. So if I suspect I need a little more flexibility, I'll come back and we'll bring that issue up. But for right now,
Keep your hands tied.
I mean, I think that the 30 is a fair split with 5% to the other two, each of the other two districts. But it really just comes back to the question of 5% of what for them. So, but if we need to, we'll revisit this in January.
Okay, any other questions for Mr. Cotton?
I have one quick comment on the meeting up there that Michael and I went to. They finally, which was part of the DFC process, they finally acknowledging private property rights in regards to water, which I thought was very positive.
Yeah, those meetings are, you can attend remotely, for those, if you don't have the opportunity to drive up to the line. Any other questions? Otherwise, we'll just table this issue. We'll, for next, either January or February. We'll bring this back. Alrighty, item 4G, presentation by attorney Greg Ellis on 2025 groundwater legislative overview. Okay, so on your dais, there's a hard copy of Texas Legislature online bill list.
Okay, things are kind of going hot and heavy. We've had over 2,000 bills filed so far. Pre-filed for a second session does approximately another 2 weeks in January for the session first, will be that Tuesday in the middle of the month. And at this point, we still, as far as I know, unless something happened while I was driving up here, we still don't have a speaker. We have 2 candidates for speaker. They're both Republicans. David Cook was endorsed by the Republican Party caucus when they met a week ago Saturday. However, he did not get enough votes to cross over the 76 vote threshold needed to be elected speaker. A number of the Republicans in the caucus literally walked out before that final vote was taken, and they are supporting Dustin Burrows. Dustin Burrows has support from a large number of the Democrats. He did present a list of 76 votes. However, since that time, several of the people on that list have withdrawn their support. And there are a significant number of Democrats who have said they're not going to support either David Cook or Dustin Burrows. Merely because of Representative Burrows' death card bill that he, quote-unquote, death card bill that he passed last session, which allows all the state regulations to completely preempt local regulation by cities and counties. So I don't know if those Democrats are trying to find another Republican to run, if they're going to try and convince Republicans to vote for Democrat. I doubt it's going to happen. Or if more and more Republicans are going to finally move over. I have heard that Representative David Cook is trying to court some of the Democrats to vote for him. At one point, there was a unanimous vote by the Democrats not to support David Cook. I don't know what's going to happen. We may go like they did in Congress. We may go quite some time without a speaker. And until they elect a speaker, they really can't, do much else. Speakers, unless they greatly change the rules and have a committee on committees to assign the committee assignments, which I don't see that happening. Will I be able to set up committees or hear bills? So it's gonna be, there's an ancient Chinese curse that says, may you live in interesting times. These are gonna be definitely interesting times in Austin. Water is again a big issue. I don't know how many bills the Texas Water Association, formerly the Texas Water Conservation Association, is tracking at this point. But it's multiple pages of the PDF. I think that number is well over 100. Not all of those apply to this body. But what we just give you an idea of what we track. We track anything that has to do with groundwater, any amendment to chapter 36 of the water code, any amendment that would happen to our enabling act here, anything filed that has to do with groundwater generally. But I also have to track any bills that have to do with political subdivisions, Public Information Act, Open Meetings Act, for my property taxing districts, anything dealing with election of property taxes. So I'm also going to be tracking the large number of bills, not all of which apply to you. The lists I provided to you today are those that I think directly impact groundwater conservation districts, or could if they pass. Starting with House Bill 279, dealing with the requirements for uranium mining. I don't think there's any uranium mining up here, but there is down in South Texas, in the Carrizo Wilcox Formation down there. And what they do is they drill a hole into the area that has some uranium, and then they use typically groundwater to create a solution and pump that solution up out, and then they extract the uranium from that solution. And so there's occasionally problems with that, but again, has a number of those operations in his district, and so he's filed this bill. Representative Tepper filed House Bill 638, which would require certain water districts, including anything ungoverned by Chapter 36, to make audio and video recordings of all open meetings and make those available on the internet. I know that you broadcast meetings on the internet. Jim, are these recorded now as it is? So I think you're already doing that. I know there's a lot of 1-person, 2-person, 3-person districts out there that are adamantly opposed to this, and we may see some. In the process, we may see some amendments to try and discount smaller districts. But this is not the first time this has come up. This is probably the 3rd or 4th session this has been filed. House Bill 755 has to do with public entities that engage in lobbying. Essentially, it would prohibit you all from hiring me to lobby on your behalf. I'm personally opposed to that bill. Well, you all may have decided it's a good idea to save yourself some money. This isn't even really become a Republican versus Democrat. This is very much a rural versus urban. Because the big cities don't, they can hire independent staff to go lobby the legislature and to keep up with their local members and attend all the committee hearings. Smaller entities just don't have the wherewithal to do that. And so the rural areas are pretty adamantly opposed to this. But the one time it came close to passing, the House passed an amendment by Representative Trent Ashby that would have limited the impact of this to the top 25 biggest counties. If you're located in one of those 25 biggest counties, then this would apply to you. And if you're not, then it would not. The sponsor was pretty unhappy with that amendment, and I think kind of dropped the bill at that point. Actually, no, I think it did come up. I think it did come up. That was voted down at that point. Representative DeRazio has filed a bill that originally been filed several sessions ago by Senator Perry, House Bill 1050, that would take the part of the water code, Chapter 36, that allows us to, we are guaranteed our right to collect our attorney's fees in any litigation, and would make that a loser pays. Meaning, if we fail, we get our attorney's fees. If we lose, then we have to pay the other side's attorney's fees. The biggest problem with that, of course, are enforcement lawsuits. If you're trying to file a lawsuit, collect a $1,000 penalty against somebody, you're going to want them to have to pay your attorney's fees. And if you're at risk of not collecting your attorney's fees or at risk of having to pay their attorney's fees, that makes that a much tougher decision in which case you're gonna want to sue for a lot more than $1,000. Because that's, you need to have a bigger bump at the other end if you're gonna take on a bigger risk. Representative Curtis has filed House Bill 1335, that has to do with underground facility safety. This specifically mentions protection of groundwater, which is why it's on this list. House Bill 1400 by Representative Harris relates to creation of a groundwater science research and innovation fund to be administered by PWDB. This is one of the top priorities for Texas Water Association. I haven't heard, in fact, I don't believe TAG has met and discussed this yet at all. But I'm certain that they will be very supportive of this and would be putting some money specifically into PWDB, specifically to help us do more groundwater science. The next bill by Representative Curtis is House Bill 1523, and it prohibits TCEQ from issuing a Class 5 injection well, which would be used for aquifer storage and recovery by certain municipalities anywhere within the Lost Pines Groundwater Conservation District. I should mention to you that the regional water plant has 3 different aquifer storage and recovery projects proposed. And I'm passing that information on to Representative Giddings. There's one by City of Austin. There's also one by LCRA, and there's also one by, can't remember, it's a GBRA? No, Aqua, Texas, that's right.
There are a couple.
No, Aqua Water?
Aqua WSC, Aqua Water Supply, not Aqua Texas.
I'm sorry. They're very different. They're very different. I apologize.
There's a couple.
I have Aqua Texas on the mind because I got a.
Oh, yeah.
There's a couple of down for the same thing.
Oh, yeah, sure. Well, because that didn't apply here, I didn't include those, but yes, for Senator Schwertner and, least Representative Wilson, I can't remember who the other, Representative Harris. Have filed bills on dealing with ASR in Williamson County as well.
When I read it, and it had population statistics. To me, I thought it was protecting only Bastrop County, but not me.
No, it's anywhere. There's a rule that applies to the size of the city.
Mhm.
And that really only applies to the city of Austin. And there's another one that says anywhere inside Lost Pines, any county
Okay,
inside Lost Pines.
let's write it down.
Yeah. So
Thank you.
it's easy, the way it's written, it's easy to confuse, really.
Yeah.
But I had the same thought when I first read it,
Okay.
it was only going to be Bastrop County. That's defining the city,
I got you.
not defining where the ASR could go.
Thank you.
Senate Bill 325 by Perry, it has to do with county regulation of subdivisions, and approval of subdivision plans or plats, and that also deals with groundwater issues and deals with the developer having to prove up availability of groundwater before they get plan approval.
Right.
A lot of developers are going around the plat process by using the condominium technique. And they're saying, we're not selling the land, we don't have to replat it, the land, we're gonna own all the land. We're simply selling a condo that sits on top of the land. And the condo could be a single family residence or a tiny house or whatever they want it to be. And so that's in litigation, in multiple areas, especially in the hill country. Senate Bill 480 by Perry, the relation to the authority of local government to enter into interlocal contract with certain governmental entities to participate in water research or planning activities. In GMA 14, that group for 20 years has allowed both the unrepresented counties, those that don't have represented conservation districts, and the 2 subsidence districts to participate in the GMA 14 planning process by helping pay for the contract. You're considering, tonight you're supposed to consider a contract for your GMA planning efforts. They did the same thing in GMA 14. Subsidence districts and a couple of the counties contributed money toward that, and by contributing money, they got to participate in what exactly it was going to be investigated and how that was going to be done. And so the Lone Star Groundwater Conservation District in Montgomery County objected to that and came out with a memo that said, we don't think that the subsidence districts have any authority to participate or vote on anything at the GMA level, which they can't. They clearly don't have authority to vote on DFCs. I think they clearly have authority as part of the local contract to vote on whatever the local contract covers. She also argued that the counties had no authority to spend any money on groundwater planning whatsoever. This bill is aimed at fixing that particular problem, to allow counties to participate in water planning, generally through interlocal cooperation act agreements. And finally, Senate Bill 501 by Colkhorst, again, relating to underground facility safety. That's a companion bill to the Curtis bill that I mentioned before. So that's where we're at now. It's gonna get bigger and better. We're gonna have a lot more bills to consider. As they move through, we'll see which ones move, which ones don't. We'll see which ones get amended as they go through the process. We already have a governance committee that I can deal with on these questions, where we need to have a meeting of the governance committee to discuss particular amendment or some particular thing that comes up. I'll be able to contact you and deal with that. Other than that, I'm gonna do my best to be here for your meetings to discuss this when we don't have any idea who's on the committees or when they're gonna meet. Have been many sessions where the House Entry Committee met on Wednesday evening, which would preclude me ever being here in person to discuss anything. I might be able to keep up with a phone call. But I will keep you update and will provide you these written updates as often as I can as we go through the process. With that, I'll be happy to answer any questions should you have or any comments you have. Just use this microphone.
There was a bill filed by 624 by Colbert to be able to deny a new or another permit based on unreasonable effects on exempt well.
I don't see that one yet.
There's an error. The Birds filed an error on that one at 1633. What's the number? What our House bill is 1633 and the Senate bill is 624.
Make sure I track that.
And there's one more that I saw. It's a House Bill 873 by somebody named Wilson. It's talking about water use for concrete company. Don't we have a concrete company in Sparks?
That's right. If you don't.
We have a lot of sand and gravel operations, but I don't think we actually have like concrete mills.
Travis.
Yeah, I think those are actually across the county line in Travis.
There are several different bills filed dealing with concrete batch plants.
One out on that.
I've often thought a concrete batch plant is less desirable than a landfill. I mean, I don't know, not sure exactly why. I guess it mostly is air quality. They do go through a lot of water, and they can have an impact on water quality. That we had one situation in Bear County where sand and gravel quarry had a large storage tank that held, what was gasoline, was that might have been their diesel fuel they were using. And somebody literally left the valve open when they filled it, and it all came out. Went straight into the quarry, went straight into the aquifers there and spread out from there. So yeah, there can be, they can cause problems, and I am tracking those as well. If they
So
deal
we just
with
don't have one.
I'm not aware of any here.
Not that I'm aware of, yeah.
That doesn't mean you can't have one at some later point, you know.
Oh, yeah. Maybe not today, maybe not tomorrow, but yeah.
Where you have sand, gravel, or limestone, you can have a concrete batch plant.
Lots of sand, lots of sand.
Any other questions?
Yeah, I've got one on,
You get the phone back or microphone.
well, I really don't need a microphone, but that's okay. For Bill 89R by Pepper, when you're talking water districts, does that go for small muds? I mean, any water district, anything at all?
Typically, yes. Typically, when they talk about water districts, they're talking mostly about chapter 49 of the water code. That covers everything from muds to, yeah, where there are many 49, that would affect every water district other than chapter 36. And they occasionally mention chapter 36.
Any other questions? All right, seeing none, thank you, Mr. Ellis. We'll move on to item 4 H, discussion, consideration, and possible action on draft 2024 budget amendment. Mr. Totten.
Thank you, Mr. President, members of the board. There was a copy of the budget amendment that was included with your board packets. Essentially, what the budget amendment does redirects $35,800 from our legal line item to cover up to even up. Yeah, to even up some of our other line items where we've overspent what we budgeted. Specifically, we're looking at moving around $5,000 to the line item for computers and software, $1,800 to cover the line item for cleaning and landscaping, $2,500 to cover lodging, $400 to cover dues and fees, another $20,000 for the building, $5,100 for repairs, and $1,000 for website related costs. Those numbers they're based on the current expenditures plus projected expenditures to the end of the year. Historically, we did these in January, which we apparently weren't supposed to do, but allowed us to be 100% accurate. So now we're doing them in December and we're having to project what we think those costs will be, but best estimate, this should get us back to even on the items where we've overspent and pull down some of that surplus in the legal line item. So with that, I'd be happy to answer any questions you may have.
Are you gonna make money for mitigation to clear up the?
It's not actually budgeted. It wasn't included in the budget last year.
It's sitting on the budget line as a negative.
That money would come out of the tax pool.
Right, they came out of different funds.
Yeah, so that would come out of the tax pool fund. So we don't need a budget amendment to correct that. That can just be balanced out through transfers from tax pool.
What's the rationale for it not being in the budget?
It's been over a year and I've slept at least once. I don't recall, but I think the idea was,
It was the unknowns that were
Yeah.
associated with it. Since we were starting it back up, there was just an unknown as to what was, the size of it.
Yeah.
And I think that's what, drove us to have a separate, pool just for that.
So January we'll be doing the new budget, is that correct?
Well, we passed the new budget last month.
Okay.
And so, yeah, now we have an item, now we did, right?
yes, sir. Now we have a dedicated line item.
Now we should.
Missed that.
Yeah, and this came from our auditor. He was the one who recommended doing these true ups at the end of the year.
Rather than in January.
Rather than in
Yes.
January. He was the one who recommended, hey, you guys really need to do this budget amendment in that budget year. It didn't make too much sense, but that was a recommendation from our
It was a lot easier to do it in January when we knew what the final
Yeah.
totals were, but yeah. The auditor said it had to be done before the end of the budget year, so.
probably. Any other questions? All right, with that, I will entertain a motion on the 2024 budget amendment.
Make a motion to approve this 2024 budget amendment.
Okay, a motion made by Director Cole. Do I hear a second? Second by Director Semang. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, the motion passes. Item 4I, committee reports with possible board discussion. No action will be taken. Financial services did not meet. So, governance committee did meet on December 4th at 9 a.m. via Zoom. In attendance were myself, Director Rogers and Semang, Natasha Martin, Bobby Salehi, and Mr. Totten. We reviewed the draft board meeting agenda for tonight. We went over the agenda, and then we discussed the auditor RFP that we're publishing to post the auditor RFP to get that for early next year. We're also planning for early next year to roll out emails accounts for all the directors so that you will all have a lostpineswater.org email. So, and we'll set up an open house or some method to update your computers or tablets or phones. So that'll be for early next year. Also for early next year, we'll have the well monitoring update that just occurred this fall. And my understanding, last I spoke with Mr. Totten on this topic a couple of weeks ago, Mr. Totten had reached out to Darling Industries. There was a concern that they were over their production limit. And Mr. Totten informed us that he had reached out to their manager, I guess, and that manager did not expect to continue to exceed that permitted amount. Do you have any newer updates, Mr. Totten?
That was number 2 on my GM report. So
Okay,
Yeah.
so we'll get to that. And then we spoke with Greg and got him online to provide the update that he just provided to you today. So with that, we'll move on.
Question.
Sure,
This is the auditor an RFQ instead of an RFP? I didn't remember.
possibly. I always get my
Oh, that's okay.
RFXs mixed up. I always get my P's and Q's.
it's an RFQ, yes, ma'am.
It's an RFQ.
Thank you.
I always get P's and Q's mixed up on that,
That's
so
okay.
I'm terrible to ask about that one. Any other questions on that report? Then we will move on to, did we have infrastructure committee?
Infrastructure did not.
Did
meet.
not meet. Education committee, I do see a readout.
Yeah.
I'm not sure if Claire's still back there. Yes, she is. Claire. You should have a hard copy on on the
Yeah,
dais here.
everyone should have a hard copy.
I was gonna say, chair of the education committee, she is doing a dynamite job. Absolutely.
Well, thanks to my committee, y'all are awesome with your leadership and helping us meet these goals. So we had a mini water fair at Emmanuel Lutheran School. I thought it went very successful. We reached 55 children between 5th and 8th grade. And I was very proud of the kids. You know, I asked them before, what do you know about groundwater? And it's water in the ground, you know, as little kids do. But by the end of it, 100% of those students were able to identify what a confined aquifer is and what a confining layer is and what it's made out of. So that was really, I was really proud of those kids. Even the 5th graders were able to do that. So that was really exciting. We had a tabling event at the Wildlife and Woodlands Landowner Workshop that was sponsored by Texas Parks and Wildlife, United States Department of Agriculture, and Pines and Prairies Land Trust. We gave out 28 water conservation kit bags. We had 5 well watch program signups and 12 newsletter signups. So I thought that went very well, very successful. We actually had someone come up to us at that event from Houston Toad Education and Outreach Working Group, and they invited us to join the working group. So I talked it over with the committee members and with Jim, and we are going to join that working group. I believe that's going to help us achieve one of our goals in our management plan, which is to provide public education on watershed protection. So I'm hoping that that will assist with us meeting that management goal. The Lost Pines Water Story, we did not receive the grant, but we're going to be working with Aqua to produce that documentary. Library installment. I'm so excited about this. We are going to have a temporary installment in the Giddings Public Library, March 3rd through the 31st, so all of March, and it's going to be on groundwater movement. It'll be very hands-on, engaging for the kids. We'll have some plaques next to it explaining what's going on. And we'll also put out some water books next to the installment. And my goal is to actually shop that around and take it around to all the public libraries in our district. And we'll once a month, we'll have that installment. So I'm really excited about that. The essay scholarship, we just went through that. And then January 25th, we're having our rainwater harvesting workshop. This is BYOB, but not what you think. It's BYOB, bring your own barrel. People will bring their barrel and we supply everything else, the tools and the manpower to make the rainwater harvesting barrel. And they'll be able to take it back to their property and start collecting rainwater. Any questions? Awesome. Thank you.
Thank you. Next up is the management committee, which we did not meet. So then we will move on to agenda item 4J, general manager's report. No action will be taken.
Thank you, Mr. President, members of the board. For the reporting period between November 1st, November 30th, 2024, we had 14 new wells that were permitted through the district, exempt wells, and then 2 pre-existing wells were registered with the district on the Form 300. During the reporting period, 3 water quality tests were performed and approximately 36 wells were gauged. I may have miscounted that, but that's my best count as of this afternoon. You'll see in the table, the drought conditions have continued to, I guess to worsen. Basically since, the end of August, we've seen rains have more or less stopped and drought conditions have slowly marched across the district. As of December, for Bastrop County, 59% of Bastrop County is experiencing moderate drought. 36% is in severe drought, and 4% has moved into D3 extreme drought. As you may recall on the drought severity scale, it only goes really from D0 to D4. So we're approaching that exceptional drought stage in at least part of Bastrop County. In Lee County, we've gone 59% of the Lee County is in D1 moderate drought, and 41% is in D2 severe drought. That's up from only 2% of Lee County was in severe drought this time last month. In spite of that, we are still, I believe for Lee County, it's still the 36th wettest year on record, and for Bastrop County, I believe it's 50th. I may have those reversed, but in spite of the recent flash drought that we're experiencing, this still has been a very wet year for the district. We've already previously discussed GMA 12, which met the 13th in Post Oak Savannah's office in Milano. We did finish up the last three factors, for lack of a better term, the postmortem evaluating the 9 factors that are required to adopt a DFC, looking at the currently adopted DFCs and looking for changes in those factors. I made a presentation to the GMA covering private property rights, environmental impacts, and socioeconomic impacts. Highlighted some changes in data and some new data sources that we can incorporate into the next planning cycle, which I think was fairly well received. As previously discussed, the cost sharing is still an ongoing item, so we'll be hopefully finally closing that circle during the February meeting of the GMA. As President Hernandez mentioned, we did follow up with Darling Ingredients, spoke with one of their vice presidents, and indirectly what they said was they were having a process problem in their plant that was causing them to use more water than they normally do. They were working on addressing the problem to bring the water usage back in line. They estimated that they would have the repairs or the process fixed within several months, but they were, excuse me, they were going to, to exceed their permit for this year. With that in mind, but not knowing exactly how much of an exceedance we were looking at, my recommendation at this point is that the district staff work with our legal counsel to develop a fee structure for basically for penalties and fines that we can apply that could also be used as a scalable model for application to other permits. Darling Ingredients, their permit is 220 acre feet. Their exceedance needs to be addressed, but it's not, it's not in the same order of magnitude as somebody with a 48,000 acre foot permit exceeding their production.
Yeah.
But this is our chance to establish a model for that. So I would like to come back to the board in most likely in January, once we know what the final annual production for the year for the Darling Ingredient permit is, and we could come back with a structure for board consideration, possible action to fine them for their violation of the permit terms, and then also that'll help set us up for any future violations that we may have. Excuse me. So Region K did meet. We met on Friday, December 6th at the LCRA and Alco Center. That's where I write these reports. And then through the course of the meeting, I just watch as people stick off the different things I had to tell you all about. Greg stole my thunder on the ASR projects, but the initially prepared plans which is essentially the draft regional plan for Region K is likely to be adopted in February. But included in that regional plan, there are new ASR projects for both LCRA and Aqua Water Supply Corporation. The regional plans at this stage, it's very general. Here's a possible strategy we might possibly use in the next 50 years to meet a demand. It's not a certainty, but it is something that has popped up that was not in the last plan. So I wanted to make you all aware of that there are other entities that are looking at possibly doing ASR projects within Bastrop County sometime over the next 50 years. Uh, excuse me. And then, let's see, finally, there was an event called Bringing the Brazos Together, which was a series of panel discussions that were held in Caldwell County. It was partially sponsored and organized by Brazos Valley GCD, Post Oak Savannah GCD, and Blue Bonnet GCD. They brought in stakeholders from the central and lower portions of the Brazos River. Jordan Fernandez from LRE was on one of the science panels. They had 3 panels that focused on the science of alluvial aquifers, groundwater, surface water interactions, the management of the alluvial aquifers, and then also on future uses. Overall, it was an interesting day to be able to see. It's very easy to get kind of lost in our own world of how we interact with our stakeholders. So it was interesting to go to another district and watch them interact with their stakeholders and see that the tone and the timbre may be different, but a lot of the concerns are the same. And so it was a very interesting day for that. The science panels actually brought up some interesting ideas about remote sensing and some other ways we could start looking at trying to develop some data sets for groundwater surface water interactions. But I think my big takeaway is that from that was looking at the real data point that we need to develop. It needs to be developed across, the GMA. It's not just us, but it's less about the interaction between the river and the alluvium and more about the interaction between the alluvium and the underlying aquifers, because that's what's going to drive more of your artesian head, more of your pressure differentials. So I think that's kind of a place, going forward that we need to be looking at. So overall, like I said, it was a good day. There was good representation of legislative, state and local elected officials. I believe Colcore's office was there, had some people there. Gert's office had some people there. So overall, it was well attended, and it was a good event. By no means am I saying we should try and do something similar, but it was a good day. With regard to pending permits, we have multiple permit amendments that have come in from Aqua WSC that we're still working through. Additionally, we have permit amendments from SLR that are looking to add some new wells to their existing well field up on the old Alcoa property in Lee County. We'll move forward with those and bring them to you as we have time and as they're ready. Try not to overload any one particular meeting with all of that. With regard to upcoming meetings, Region K is meeting January 15th. And again, on February 12th, those will both be at the LCRA Rosebud campus. And then GMA 12 is scheduled to meet February 21st at Post Oak Savannah. And with that, I'd be happy to answer any questions. Yes, ma'am.
Hey, was the presentation that you gave at GMA 12 extemporaneous, or is it written and we could get a copy?
There's a PowerPoint, but I didn't write a speech or anything like that. No, ma'am.
Okay.
But it's also,
wanna
the
share it?
video should be available through GMA 12.
Okay. Or could you just send it to me?
The video or the
No,
PowerPoint?
no. Just the PowerPoint.
Just PowerPoint? Yes, ma'am. Let me make a note of that.
Okay, thank you.
Typically, that's put on the Post Oak Savannah GCD website.
I'm just not that advanced.
All right, any questions for Mr. Todd? Seeing none, then we'll move on to item 4K, consideration of future agenda items. What I have for January, the elections. So that's the only thing I've got. Anything else? All right, so yeah, because every January, so once a year, we do go through the elections, so that'll be coming up in January. A discussion, consideration, and possible action on district board meeting calendar. Anything on that? I don't have anything on that. Okay, then finally 4M, the agenda item, setting the date and location of the next meeting. I believe it'll be on January 15th, 2025. In Giddings, Texas, here at 3:30 p.m. So with that, I will adjourn the meeting. Meeting is adjourned at 5:41 p.m. Thank you.